Hello friends, in this video we will discuss regarding an important topic of Industrial Dispute Act, that is Unfair Labor Practices, ULPs. As the name suggests, unfair labor practices means whether something is getting bad with the labor, or on the other side labor may also indulge in some bad things. So which is unfair? So unfair labor practices has been defined under section 2 subsection RA of Industrial Dispute Act. So the list is very exhaustive. What are unfair labor practices? So a list cannot be discussed in brief. That is why it was very difficult to provide a clear definition. So all those things which law discussed to be unfair, it has been given under schedule 5. So you have to remember this schedule 5. This is the schedule under which the Act has given some practices which will be considered to be unfair. Therefore, the definition given under section 2 subsection RA, it simply says that unfair labor practices means all the practices which are given in the 5th schedule of Industrial Disputes Act 1947. Now to discuss this 5th schedule, you have to keep this point in your mind that this 5th schedule has been divided in two parts. First is when the labor practices are being done by the employers or trade union of the employers. Second part will be dealing with on the part of employees, that is workers or trade union of the workers. So some things cannot be done properly by the employer, while there can be certain practices which are wrongfully done by the worker also. So first of all, in the first part, we will discuss the practices which are done by the employer and their unions. Now what employers can do? They can interfere, they can restrain people, they can coerce, they can make them fearful, right? So they can exercise their power because the employer in such a position that he can exercise undue influence on their employees. So they can interfere with their duties. So first point is when to interferer means to interfere with, to restrain, to stop them, to coerce them, to make them fearful, the workmen in exercise of their rights. Whenever the employees are asking for their rights, you are making them scared, you are making them fearful. Whenever they want to organize, make a trade union or join some trade union or assist in a trade union for any concerted activities for the purpose of any collective bargaining. So whenever they want to put up a point in a collective manner and they are being coerced, interfere or restrained from doing, this will lead to a unfair trade, unfair labor practice. Second is to dominate them, to interfere or with or contribute support, financial or otherwise, to any trade union. It is not the duty of the employer to provide support to any trade union. But if the employer is giving support to any trade union financially or otherwise, that is an unfair labor practices. To establish employer sponsored trade union. Trade unions are always designed by the workers. So when these are sponsored by the employer, so there may be a reason of doubt. So that is unfair labor practice. To encourage or discourage membership of a trade union. They should not encourage, they should not discourage the appointments in the trade union. It is the wish of the workers to be a part or not of the trade unions. By discriminating against any workman. If worker is a part of the union, they are giving positive response. The worker is not a part of a union, they are giving discriminating response. All this lead to a unfair labor practice. To discharge or dismiss a workman. The worker who is working in a regular form, still we are not giving him work. We are discharging him, dismissing him, not providing him such work to contract as a measure of breaking a strike. So we want a strike to be broken, so we are trying some strategies, that is an unfair labor practice. To transfer a workman malafide from one place to another under the guise of following the management policy, just showing off that it's a management policy, and willfully we are transferring one worker to other place so that the trade unions break, or to deceive the worker. Such things will be leading to unfair labor practice. Similarly, to insist upon an individual worker who are in a legal strike to sign a good conduct bond as a precondition to allowing them to resume the work. So whenever there is a strike going on and a good conduct bond is being created and there is a precondition that you are not allowing them to resume the work, it will be considered to be an unfair labor practices. To show the favoritism to one set of workers and being just negative to the other set of workers regardless of their merit, it will be called an unfair labor practice. To employ the workmen as badli workers. Badli worker are the casual workers. They are not the regular workers. They are the temporary workers. So they want to deprive them from the benefits of being regular workers. This is an unfair labor practice. To discharge or discriminate any worker for filing charges, for testifying, as the workers have to conduct various tests. Some are paying the fees for tests, some are not paying. So you are discriminating them. Or due to any inquiry or any dispute going on, this will be called an unfair labor practice. To recruit new workers during the strike, which is not an illegal strike, workers have gone for a legal strike. Still, you are recruiting new workers during the strike, it will be called unfair labor practice. Failure to implement any award, any settlement which has been given by the courts, labor court, industrial tribunal, but that award or settlement is not implemented, it's an unfair labor practice. To refuse to bargain collectively in good faith with the recognized trade unions. Trade unions are having a right that they can bargain for their rights, for their payments. So you are not giving them the opportunity, it is unfair labor practice. Proposing or continuing a strike, a lockout, which is illegal under the act. A lockout is generally done by the employers, which is illegal, and you are continuing it. It is unfair labor practice on the part of employer. So this was the first part of the definition. Now we are coming to the worker. Now in some cases, workers can also be wrong. They can also indulge in unfair labor practices, and the examples of which are to advise or actively support or instigate any strike which is illegal. If workers are indulging into a strike which is illegal, it will be called unfair labor practice. To coerce the workmen. Now you are just trying to scare your co-workers in exercise of their right to self-organization or to join a trade union or refrain from debarring you joining any trade union. You are making them join a trade union or you are telling them not to join a trade union. So you are just trying to make the other people fearful. So that is unfair labor practice. You are indulging into other methods like picketing, or you are showing a very bad behavior towards the worker who have not gone for strike. So you are not allowing them to work, to just involve in the acts of force, violence, threats of intimidation in connection with the strike against the non-striking workers. To go on a strike or not, it is the wish of the worker. The workers who have not gone on strike, you are just trying to scare them, or against managerial state. For recognized union to refuse to bargain collectively in good faith with the employer. Now the workmen are not ready to sit with the employer and bargain. That is also unfair labor practice. To indulge in coercive activities against certification of a bargaining representative. You are coercing, indulging into the coercive activities. To stage, encourage, instigate any coercive activities as willful, go slow, squatting on the work premises after working hours, or ghirao, or any of the members of managerial or other staff. You are just involving yourself in such activity. Go slow means doing the work slower, willingly, without any reason. Or ghirao means just you want to have a ghera around the people of managerial persons without having any legal strike notice. This is again unfair labor practice on the part of workers. To stage the demonstrations as the residence of the employer. You need not go to the residence. Whenever you are having any problem, that can be done professionally, officially. So when you are going to the residence of employers or managerial staff, it is unfair labor practice. To incite or indulge in willful damage of the employer's property. You can go on strike, but you cannot damage employer's property. It is unfair labor practice on the part of laborers. To indulge in the act of force or violence or to hold out threats of intimidation against any worker to prevent him for attending the work. You are stopping your co-workers to work. It is an unfair labor practice. So we have seen that there are two parts of the definition. One is from the point of the view of employers and other is from the point of the view of employees. Now another important point is this prohibition of doing this unfair labor practices is given under section 25 subsection 7. It states that no employer or trade union of workmen, neither the employer nor the workmen or their trade unions will be committing these unfair labor practices. And section 25 subsection U tells about this penalty. If you are still indulging into these unfair labor practices, it will lead to a punishment which may extend to 6 months or a fine of rupees 1000 or both. So if anyone is indulging into these ULPs and it is proved, so there can be imprisonment of 6 months, there can be fine of 1000 or both. So this was all about unfair labor practices. Thanks a lot.